First, let me say that it's a really pleasure and honor to meet you. I've seen your work, I've heard about your work, but it's the first time I'm in this meeting. And we had the opportunity to work during the COVID, during the Ukrainian immediate crisis and what followed, and now the Red Sea. I've been really, oops. That was to wake you up.
Yeah.
So it's a tremendous work that you do, and I'm really pleased that if somehow we can cooperate with this, and also at the end have some discussions. I think Jason wanted to discuss, and feel we had some discussions also. How can we better interact, or how can we ILO can better benefit from the information that you get, which is very valuable because you are on the ground and because you talk to seafarers. So this is like going like this. Where is it?
Yeah.
Okay. So in this ambitious, very short presentation, Jason wanted me to go back just very briefly on the origins of the ILO. For those who, are you all familiar with the origins of the ILO? Not necessarily, many other things. So I think it's interesting to mention that the ILO was created in 1919, so at the end of the First World War, and the constitution of the ILO is a part of the treaty, of the Peace Treaty of Versailles. So those who, the UN was created after the Second World War. So this is the only organization that exists since 1919. We celebrated the centenary not so long ago. But what did this person have in mind when they created the organization? They believed, they were convinced that sustainable peace can only be based upon social justice. We need social justice, and I think we are convinced, those who work for this organization, if we want to maintain political peace. So they decided to set up this organization with this ambitious objective of social justice. And in order to achieve that objective, the main tool that this organization has is the adoption of international labor standards. Conventions, treaties that will apply across the board in all the countries. We have 187 member states to regulate workers' rights. And the ILO not only adopts conventions, it also supervises the implementation of these conventions. There is a whole mechanism that I will not describe today, but whereby governments report on how they are doing. But also, workers and employers organizations have the right to complain, to say, this is not working, and somehow this information that is on the ground is not always reaching us. So I'll say more about that. But there is also this technical cooperation part. We do not only adopt standards, we also work with governments, workers and employers organizations on the ground to try and implement these standards. So we have offices around the world, and the colleagues sitting in those offices are working with the judges of the countries, with the legislators of the country, with the trade unions, trying to get the implementation of these standards. And also, of course, we conduct research, especially in the new areas. For instance, now digital platforms, the workers in digital platforms, how to regulate their work. Of course, artificial intelligence, but also teleworking. During the pandemic, we had all these teleworking arrangements without necessary regulations. So the ILO is also playing a role studying in those areas. So the other key aspect of this organization is tripartism. It's the unique, only UN agency which has these characteristics, which means that we do not only have governments, we also have workers' representatives and employers' representatives sitting on an equal footing. For those who have been to the IMO field, at the IMO, the seafarers and the ship owners, and you also, are seated at the back of the room. Yes, you have the right to take the floor as observers, if you're sitting at the back. At the ILO, workers will be seated here, employers will be seated there, and governments in the middle. They all have a spokesperson. They have the right to vote to speak on an equal footing, and they also have the right to vote. So it's completely different. What was the idea? The idea in 1919 was we have to work together if we want progress, if we want to achieve the social justice. And so these three keys here are real keys, they exist. The first building of the ILO has a door that you could only open with the three keys at the same time. So the idea was that the worker representative, the employer, and the government will turn the keys at the same time in order to open the door. We have them, and it's just a symbol of how this should work. And if we speak about the MLC, and you see it all the time, governments are requested to work with ship owners and seafarers organizations because you are as a government, you are smarter in the sense that you know what is going on the ground. Otherwise, you don't have that information. You can interrupt me anytime or ask a question or make a comment, please. So on the MLC...
Does that door still exist?
Sorry?
Does the door still exist?
The door is no longer there because in fact, maybe it's the ILO building is now the building of the World Trade Organization, the previous one. So we kept the keys, and in fact, every time there is a celebrity coming to the ILO, they will receive a copy of the keys, but the door, it's not, I don't know where is the door. Jason, I will find out. So on the MLC also, 2 words about the origin, because not everyone knows. When you look at this document, that's the MLC. I'm sure you have all seen this convention. It's huge. Normally, ILO conventions have 2 pages, 3. So this is the only, I'm not very lucky, I have the worst one, is the only convention with 100 pages. Why do we have this such a complex and comprehensive convention? Because the history of the MLC started with the creation of the ILO. Already in 1919, there was a discussion recognizing that seafarers had special needs because they not only work on board, they also live on board, and because of the international nature of the already very international nature of the industry, the maritime sector, they needed specific protection. So the year after, 1920, we had the first International Maritime Labour Conference in Geneva, which adopted the first conventions to protect seafarers. And since then, until 1996, the ILO adopted more than 70 conventions and recommendations to protect seafarers. All areas of work and living conditions of seafarers were regulated. So why did we need a convention, another convention? Because those conventions were poorly ratified and poorly implemented. And therefore, the idea came from the ship owners and the seafarers. They agreed, and this is what we call a social dialogue. They together came up with a resolution asking for the adoption of a new consolidated document, convention, which would modernize, adapt existing conventions, but that would in particular have an enforcement mechanism to have those conventions somehow applied. And that was really, I don't know, Stewart, how do you would describe it, or Max? For me, when you look at the time, and when I see the discussions in other areas, regulating aviation or regulating other areas, it was really a crazy, wild dream to believe that that could happen. And indeed, governments supported the idea. And after several discussions in 2006, the convention was adopted. So this convention has a twofold objective. The first one, I think is the most important one, is to protect seafarers, workers and seafarers' rights. But the second one, equally important, I would say, Max, is to ensure a level playing field for ship owners, for good ship owners, for responsible ship owners. So when you look at the convention and the mechanism in place, of course, those 2 elements are there. The idea is to protect against unfair competition by irresponsible ship owners or by ship owners that are not treating the seafarers as they should. And so, I don't know, where is this thing? So I think Jason, you wanted me to highlight just one aspect of the MLC is how it is amended. This convention, or maybe I'll say just a few elements if you're not familiar with. In addition to consolidating these previous instruments, it covers all aspects of working and living conditions, from when you have to go on board, the minimum age, your medical certificate, the training that you have to have, how are you recruited, to your contract as a seafarer, your wages, hours of work, your repatriation rights, the manning, how many seafarers are we going to have on board, that's also regulated, annual leave, the time that you need to rest to be also fresh, the accommodation, there is a whole title that we all hate, the lawyers, because it's very technical, is how the ship is built, how is the bed, the cabin, and in my time, these are little details, but of course they are crucial for the health and the welfare of seafarers. The vibration, if you after you have your limited hours of rest and you go to bed and your bed is vibrating, you can't sleep, of course that has an impact on your health and on safety of navigation, depending on what is your role on board. The issue of safety and health, medical care, social security, that's also regulated. And finally, the Title 5 of this convention is the whole system of inspection and certification of ships. There is a system for the bigger ships, more than 500 gross tonnage, going internationally or among international ports. They will have to have a certificate. They will have to go through an inspection and have an MLC certificate that will be delivered by the flag state, but that will be also, or can be controlled by port states when that ship enters a port state. So all that system was not created at the ILO. It's unique at the ILO. It was important, and feel, those who know very well the IMO, this was taken, or those who drafted the MLC inspired themselves from the IMO conventions. Some old, there was another previous ILO convention which also has some kind of port state control inspection. But what I also wanted to highlight here is this simplified process of amendment, because I think it's important for what you're going to present afterwards. Again, in the ILO, if you want to modify a convention, you have to adopt a new convention. So that takes forever. And in addition, when you adopt a new convention, you need a ratification of that convention. It has to go through the parliament. It's a long time, and you need to convince everyone that you want to ratify this convention. So those who created this system, I think, were very smart. They were inspired, again, by the SOLAS convention, the IMO, but they have this system whereby any of the groups, ship owners or seafarers group, they may initiate an amendment. Also, 5 governments may initiate an amendment. That amendment will be presented and discussed where in this tripartite body that is created in this Article 13 of the MLC, that is called Special Tripartite Committee. And in this committee, we can have seafarers, governments, and ship owners sitting and voting and speaking on an equal footing. So that amendment, when it's presented, is transmitted to governments for comments. They have 6 months. Then we discuss in this meeting. It is amended, sub amendments. We have all the discussions that we need to agree on a text. Is voted. Then it goes to the International Labour Conference, where all the governments will again have to adopt it. So it's countersigned by many people. And so at that point, it's notified to governments, and governments have 2 years to oppose. If they do not oppose, they are bound by the amendments. This is called tacit acceptance. No ratification is needed. And why is it interesting? Because now, for instance, you're thinking about this amendment on shore leave. Well, if it is adopted, most probably it will be enter into force for all member states. Some, like for instance, for the 2022 amendments, only 4 states opposed. So the majority of the states, once you have had all those discussions, they follow the group, let's say, and they will implement the amendments. So in terms of where are we today, which was the next question in my exam, Jason, we have today 108 ratifications. So that's huge for any ILO convention, and in particular for a maritime convention. But in addition to the numbers, I think what is interesting is this figure. They represent, this 108 represents more than 96% of the world fleet. And they include the larger labor supplying countries in the world. We have the Philippines, China, India, Indonesia, Sri Lanka, Myanmar, Madagascar. You were saying that it's important. But the main, Ukraine has still not ratified, but we are working with them. And I say 108 plus because, of course, many other countries are working, and we are supporting them in the process of ratification of the MLC. And just one technical detail, but is important, the MLC has also imported from the IMO this clause, non more favorable treatment clause, which means that if your ship flies the flag of a country which has not ratified the convention, but you enter a port of a country which has ratified the convention, you have to have at least you can be requested to provide at least equivalent protection to those seafarers. So very concretely, Turkey has not ratified the MLC. If a Turkish ship enters Germany, the German port state control officers may require equivalent protection to the one required by the MLC. And that's an excellent idea that does not exist in any other ILO convention. And this has triggered ratifications, because ship owners have gone to the government saying, please ratify, because in any event I need to comply, so please ratify. And even, for instance, again, Turkish ship owners, they are very much favoring ratification, but they have not been able to convince the COP. For some reason that I ignored, Paris MOU decided that the certificate, the MLC certificate that is issued to US internationally going ships was going to be accepted as an MLC certificate, when in reality you couldn't do that because a country that has not ratified the convention cannot issue certificates under the MLC. And I read an article by a QS academic saying that the day that happened, the possibility to have a ratification of the MLC finished, because the need for ship owners to have, and we know there are not that many US ships with a US flag, many have other flags, but that is still ongoing. So ships are, let's say, they have the MLC certificate is some kind of protection. It's in the legal terms, it's called prima facie evidence of compliance. So in principle, you are protected by more detailed inspections because you show your papers. If everything is in order, you shouldn't have an additional inspection or more detailed inspections unless there are complaints. And yeah, again, the role that you play with seafarers, where you hear a lot of complaints and a lot of things are not going on, they should know that they have this right to complain that can activate more detailed inspections. Yes.
Yeah, I was just going to add that because of this no more favorable treatment, this is why the idea of consolidating the conventions was just as much actually came from the social partners involving the ship owners. This is something that we wanted, and that's why ship owners have been some of the staunchest promoters of this widespread ratification, joining every single workshop, meeting, delegation, either ILO organized or national and so on, to promote it. I'd say in terms of ship owners now, the big country that we are missing and looking for, leaving aside US and the Turkish situation, is of course Ukraine, but I think we can all be quite understanding of that situation at the moment, because that's the one, in addition to no more favorable treatment, if a country is not ratified, and we source large numbers of crew, and MSC, we have about 8,000 from Ukraine, last I checked. It fluctuates a bit and so on, but I think it triggers the need to do a little bit more due diligence on our side to ensure that manning and recruitment agencies operating in the country are fulfilling all the obligations that you find in that regard in the MLC, whereas if they had ratified, as a ship owner, you can rely a little bit more on implementation and whatever system the ratifying party has. So for us, I'd say Ukraine is still a little bit on the list. They're a huge labor supply country. You must see them in your ports, and you must visit them on ships and so on. So just to note about our promotion, and just to flag Ukraine as one more.
Yes, no, and thank you for mentioning this, because this year we had the Ukraine Maritime Forum, and I had the opportunity to talk with the Ukrainian authorities, and we've been working with them for years now to ratify the MLC, and they said that they were ready now, even with all this context, to continue working on that. They have an issue because they have created a ministry, reorganized the minister in charge, but we are working with them, and we are also working with the US, by the way, because we don't believe there is you laugh, but in any event, because there are no immune countries, so we have to work with all the countries. So whatever you can help in any way, many of you know you are based in the US. Thank you in advance for your support. So how are we doing? Very bad.
No,
2 minutes.
No. We have plenty of time.
Plenty of time. So in terms of implementation, so just to let you know, what is the overall situation? And then I'll come to the less happy part at the end on the challenges. But we at the ILO have reviewed more than 100 first reports. This is when a country ratifies the convention, 1 year after they have to send a report indicating provision by provision how they implement the convention. What are the relevant circulars, the regulations, the practices, how they give effect to the convention. And we have reviewed that. I'm part of the Secretariat, but there is a dedicated body that has this very long name, ILO Committee of Experts on the Application of Conventions and Recommendations. This is a body of 20 experts coming from different countries around the world. And they assess, these are very long, 200 pages, comparative analysis that we do. And then they issue comments indicating what are the problems. And the overall assessment is that they are impressive efforts to adopt laws and regulations to give effect to the convention. So we see the large majority of countries in different levels of accuracy, they have adopted laws and regulations. They have either copy-pasted the MLC in their national legislation, which is not we actually want, because the MLC is just a floor, it's a minimum protection. You can, of course, give more, or they have amended the existing laws to give application to the convention. Then we also see in terms of implementation that the port state control memorandum, these groups of countries that inspect ships coming into the ports, and I'm sure you're familiar with them, or you must be at some point be in contact with them, they are playing more and more each time a more active role in relation to the MLC. Is it perfect? It's certainly not. Is it an equal implementation? It's not the case. In some areas, of course, the Paris MOU is the most active. We see now a lot of implication on the Tokyo MOU, and we are working with other MOUs. For instance, we were recently in a seminar with the Abuja MOU with inspectors from Africa. They lack the knowledge about this convention. And the easy challenge, because many of these inspectors are engineers. They come, or former seafarers, or most of them are engineers. They don't have a labor law background. So checking, something is to check the engine and can go and check if the engine is working, or something else is to check and is to look at the seafarers in the eyes. First of all, this is what we train when we train our inspectors, is to how to start looking at the people, not only looking at the ship, and then checking hours of work. Okay, that's in a CCW, but also checking other MLC requirements might be a challenge for them. And also, I just wanted to point out the International Transport Workers Federation's inspectors, because they also play a role. They do not supervise the MLC, and they are not part of the MLC formal system, but they know much better labor rights issues. They have many years before the MLC because of their collective agreements. So we see a cooperation in some cases. Some ship owners do not necessarily like it, but there is this cooperation between ITF inspectors and port state control inspectors, where they can be taken as experts on board to say, well, how let me help you look at this. Let me help me looking at these contracts, for instance, the seafarers employment agreement. How does it work? So all that is going on. And now moving to the challenges, there are many challenges. I know there's no way you can read this PowerPoint. I wanted to put all this here so that you have it as a reference. No, Jason, they will receive, I understand, this PowerPoint. But some of the recent developments, and Jason wanted me to discuss about the last amendment. There have been, since the adoption of the MLC, 4 sets of amendments. This refers to financial security, harassment and bullying, piracy, the protection in case of how seafarers should continue to receive their wages if they are held captives by pirates, or in case of armed robbery. And the last ones is the 2022 amendments are all these ones that I'm not going to go through all of them, but they will enter into force at the end of the year. What is interesting about these amendments is that many of them, and Marx was the spokesperson when these amendments were discussed, and at least 4 amendments were presented jointly by seafarers and ship owners. What is one very important amendment? These amendments are many of the lessons learned from the pandemic. So just to highlight, I personally believe, and I'm very proud, Marty should be proud also, that we will have an international convention. So December 2024, when these amendments will enter into force, we will have an international convention already taking on board some of the lessons learned during the pandemic, some of the very difficult lessons learned during the pandemic, and I'm sure you had to accompany seafarers in many of those cases. What was one of those lessons learned? We had this a master who passed away, and he was on board, his body was on board for 5 months, and 12 ports rejected the disembarkation of his body. So he didn't die of COVID. They didn't know what was the cause, but it was not COVID. No one else on board had COVID. And so the case came to us. We normally do this, these are called urgent interventions, and we write letters to governments. And I was in this situation writing the letters, and I say, does it make any sense to write letters to these governments? So we just asked, what is the next port of call? And we started calling and phoning the authorities in that country, and eventually we got the disembarkation of that person who was then repatriated. So that is now an amendment to the MLC, and there is an obligation for the country in which, when a seafarer passed away, if it is in the high seas or if it is in the territory of a member, the first port has an obligation, binding obligation, to repatriate the body or the ashes of that seafarer. Another very difficult lesson learned through an example, we had this, again, request for urgent intervention of a seafarer who was dying of tooth pain. And the port has said this is not urgent. This is not in need of immediate need of attention. So please wait until the next port. I don't know, those who have suffered from tooth pain, you perfectly know what it means. So now, that was one example, but we had cases of people who couldn't breathe, and then they said, just wait, and someone who survived by chance, we don't know how he couldn't breathe, and he had to wait another 5 days until the next port. I'm sure you've seen all those cases. So now, and then also the many suicides that we had during the pandemic. So now there is one of the amendments is a clear definition, or at least a list of issues of what is in need of immediate medical care. And that includes acute pain, that includes risk of suicide. And I think this also for you and for the follow-up of your work, how are we going to determine if a person is or not in risk of suicide? That all that will be seen. But I think because you are in contact with the person, I mean, you know, you talk to the people, and you might also be aware of these kind of concerns from seafarers. This is a new area that is opening now. It's also now the mental health. If you are obliged, you or state are obliged to give medical care to a seafarer who is on risk of suicide, that implies opening a door to taking care of the mental health of seafarers. Another very important amendment that also came as obvious result of the pandemic is access to social connectivity. It's a right to social connectivity, the right to internet connection. That was another very tough discussion, Max, as you recall, because the issue was cost. There are two issues. One is cost and who it pays. Seafarers wanted this at no cost for the seafarers. They didn't get that. They get in principle at no cost for the seafarers. And if there is a cost, it should be reasonable. So why was this so important? During the pandemic, the seafarers were isolated from their families. They couldn't know what was going on when families were sick, when family members were passing away, etc. So that is, I think, a huge achievement by the international community, not by us, to have this and keep up with our time. And you remember, Max, there were a lot of discussions, no? And at some point, the spokesperson of the workers, the seafarers, said, who would have come to Geneva for a week if you had to come without access to internet? And it was funny, when you were there, Stuart, no? All these governments, everyone was on the phone, and all of a sudden, or the iPhones, or it's true. Now we all use internet for all kind of purposes, to read, to learn, to etc. So that's a right now. Of course, there is the other part. How are you going? We are all going to help seafarers as we adults, to make sure that there is a balance. There is the issue of fatigue, the issue of isolation. How do we take care of all that? Companies, I'm sure, Stewart, I'm sure you're working on that, will have some kind of regulations, because it's not that you will have access for free and stay on your watch looking at your phone. Of course, that's not the idea. So I'll stop there. There are others, but yeah, do you have a question?
Just on the internet thing, I think there's full support and understanding from ship owners, and if you heard reporting from the discussions about the internet connectivity, it would sound, you could get the incorrect impression that maybe ship owners of the industry didn't want to pay for it, or many other reasons. But in fact, wasn't really the main issue. The thing is, cost isn't the main issue. In fact, even though MSC Cruises, our cruise fleet, maybe paid roughly 25 million euros last year for internet connectivity on board our ships. And MSC, I'm proud to say, has free internet connectivity for all crew on both the cargo and cruises fleet. Of course, there are some restrictions, sites that can't go, certain data limits that cannot be, and you must see in many of the ports and during your visits that internet connectivity is going only one way. And since Elon Musk is not totally imploded yet, and Starlink is working and everyone's installing it, the possibility for ship owners to provide more and more internet is only going to get better. More competition in the market also would help, and the cost will come down. And I think, looking at Max as well across the room there, I think we believe that the trajectory is going the right way for internet at sea. One of the sort of considerations that maybe is immediately recognized by ship owners is most things that are to do with ship systems and equipment tend to find themselves quite rightly in IMO conventions, which are subject of various certificates, regular inspections by class societies, flag states inspectors, and there's a very known process for what to do when a piece of equipment breaks down. Normally, you quickly tell the engine or deck superintendent that something's wrong. The flag is informed, they issue a letter. The ship or its agent or the company maybe contacts the next port of call. And so there's full visibility and awareness, and there's a system of understanding. But if we create something that really relies on actually a piece of systems and equipment as a right in maybe a maritime labor standard, then we might not benefit. So whereas I always give the sort of abnormal, and it's just hyperbole, I suppose, but it might be possible to sail without a chief engineer, but if the seafarer couldn't send one picture of the sunset to their partner back home, the ship might not be able to sail, because we are quite used to how we deal with things breaking down and not working on the technical side. So I think there are some sort of deeper considerations that maybe don't quite get reported the way ship owners we'd want to, and maybe we don't express ourselves sometimes best, although Mac's very eloquent, of course. And so there's maybe some deeper considerations around why it's not easy to just write a mandatory right to internet at sea for seafarers in the MLC tomorrow. But I think we're getting there. All the trends and trajectories, if you look at it, are going the right way. So I hope that's, sorry to keep disturbing your presentation, but I think we are going to get there, and don't worry. And MSC, we're quite proud of the internet that we do provide already to our crew.
Yes, please.
Yeah, I noticed on your amendment there, you've got, I'm squinting to read it, access to shore-based welfare facilities. And I think of all the questions that I get across my region and really across the globe, really, the one that comes up time and time again is that chaplains say that seafarers would like to get off and come to their centres, but they can't for whatever reason they're given. What is the, I'm sure there isn't a definitive right, but where does this sit? Where does the right to shore-based facilities sit?
Yeah. That's I think it's a good question to introduce at the last slide, because it's what are the challenges, and one of the challenges, of course, universal ratification of one challenge, we have to continue working, but the other one is harmonious implementation in law and in practice. Some countries have a beautiful legislation, in practice it's not working. We need to raise more awareness about the MLC. Because many of those who are also refusing shore leave, etc., might not be familiar with the obligations under the MLC, and we need to continue working to have strong flag state and port state control who can recognize those kind of I would say violations of the convention, like the denial of shore leave. When we list some of the main problems that we see, of course, abandonment is one, delays in the payment of wages, criminalization of seafarers, violence and harassments, fatigue related to minimum manning and hours of rest, and is there denial of shore leave. We do not have empirical evidence because in many cases these issues are not reported to the ILO, but when any event, any activity, any discussion with seafarers, with ITF inspectors, is that they face this continuous problem, and with ISWAN and yourself, that they continue to face these issues of denial of shore leave. And that's and what are the opportunities regarding that? Cooperation, enhanced cooperation between social partners. I think, Max, you might speak about that, but we've seen that in many areas, seafarers and ship owners at the international level are working together, even if, of course, they have their differences. There have been some meetings, and there will be another one at the end of the year, or IMO-ILO meeting, so where we work together to address the issue of common interest. As Stewart, you were referring to this, it's covered by maybe two organizations more or less should work together to address these issues. We had a meeting on abandonment, another on harassment and violence, and the next one is coming on criminalization at the next of the year. And then we have the STC next year where that issue could be addressed. Yes?
Yeah, I was just wondering what we can do and what maybe in the future in making people aware of MLC 2006. I can only talk about the UK, but we in some scenarios are talking to really senior maritime professionals looking after major port setups, and sadly the government as well, and they've never heard of it. I've had to sit in a very high-ranking chief executive's office and explain what MLC 2006 is. Now, we work with that every day. In fact, I would say that our frontline staff, our chaplains, understand MLC 2006. Yet these key players, how can we get them to have this in their everyday thinking and vocabulary? Because it's a real problem. I'm talking about, I can't mention names, but you're talking about right up in the UK, certainly, to the top of government and to people in major posts, have never heard of it. And that's worrying.
Yeah. And that came during the pandemic. It was so happens that so many people were not first. It's not only the MLC, it's seafarers' rights. Seafarers, first of all, maybe shipping also. And people do not realize the importance of shipping until they have a problem. They don't, most of the time, if you look at the news, there is an issue with the ship. It seems that it's an autonomous ship because there's nothing, you won't find anything on seafarers' rights. So please, any ideas? Awareness about the MLC is one of the things we identified after the pandemic in common work with all the UN agencies, the IMO, the World Health Organization, all the others. We need to raise awareness about the MLC. So any kind of campaigns, we have created an app that is available on the phone for seafarers that will frequently ask questions on the MLC. No, it's not for seafarers, it's for anyone. It's any government, anyone can have access to that. And so, any support is welcome in that regard. Yes.
I just wanted to make another comment. What especially Andrew also said, there's also another angle that not only shore leave, but where I come from, we are bluntly refused entry to some of the portions of the port. So you can't get the ships. So there's another side of it as well.
Yes, and I get it. So, because I didn't answer precisely to your question, where does this right sit to? This is Regulation 2.4 of the MLC. It says seafarers shall be granted shore leave to benefit their health and well-being and consistent with the operational requirements of their positions. This is what we have in shore leave, apart from some references here and there. And this is why I believe ICMA has promoted this, and I hear that you have support from several important actors, because something else was needed or apparently is needed. This alone is not working. And so the legal right is there, but there are normally all the other rights, they have a general rule and then details on how that right should be implemented, even non-binding details, suggestions on how to implement this right. This is lacking here, so of course this will hopefully will give more clear direction instructions to all the actors on how to exercise this right. And then something we've been discussing with Jason, of course we do not promote complaints. But there are mechanisms, complaint mechanisms. And so if a port, a country is systematically denying access to shore leave, for instance, for seafarers, even if the ship owner wants to, well, those mechanisms, ILO mechanisms, they have to be activated so that we, from the ILO, can at least intervene. It can be also a request for urgent intervention. These are more informal procedures. Otherwise, you would need to go through ICS or ITF. You don't, ICMA doesn't have the standing, you have to be a workers or an employees organization, but you can channel those complaints so that we can address them. I think it's one problem can occur here and there. If it is a systematic issue, it's important to address. And so that the last thing was what is on the agenda for April, next STC, from what we heard, because, I give you the floor. 10 September is the deadline to submit proposal for amendment. So I still don't know. We've heard that there will be, again, it's very small. I can't even read it, so I imagine you, I'm so sorry. Maximum periods of service on board. That amendment was discussed the last time. It was not adopted. I'm not looking at Max here. and it will come again. Repatriation to the seafarers home, not only repatriation, that was also discussed last year, was not adopted. It will have to come again. We will see what happens with that. Harassment and violence, there will be not only one, but these 3 amendments on harassment and violence. Recognition of seafarers as key workers is very important after the pandemic. I understand there will be a joint proposal, seafarers and ship owners, on that issue. I understand they are still working on that. Fair treatment of seafarers, shore leave, and hours of work and rest. So those are some of the areas where we've heard. We haven't seen the proposals. So sorry, you had a question. And then I give the floor to Max because I'm taking too much.
Yes, my comment is, I agree that MLC 2006 is a wonderful tool. It is our experience. But for me, it has a weak point. And it is when the point B44 speaks about welfare services in port. They said it should have, it would be, but it's not compulsory. And welfare services in port are very important for seafarers. And what's the problem? That it depends a lot of the goodwill of the port community. And these welfare services has to be paid. And who pays for it? In some ports, there is a tradition that for each ship they pay some, but it's not compulsory. Yes? In some few countries, it's compulsory. For example, I know that in France, they have since a couple of years that for law, a certain percentage of the port taxes should be dedicated to seafarers' welfare in port. Because it's very nice to say that there should be a club, free transport and everything, but who pays for it? And seafarers' missions mostly have not much money. And I repeat, this depends a lot then from the goodwill of the port community. And not always is this goodwill. So it should be, I know it's very difficult, but maybe the goal should be that all ports, all countries should dedicate a percentage of the taxes that the ships pay when it comes in port should be dedicated to seafarers' welfare. I know this is not easy, but we should think about this or something, but it's not enough how it's now.
Yeah, no, just to absolutely confirm what you're saying, see what we see the same from the ILO, because when we assess the provisions and we examine the reports from the government, some governments will say that we don't have welfare facilities. And because the convention says that they are invited to, we can ask, please keep us informed if there are any developments. The next time they say there are no developments, we don't really have a legal basis to keep insisting because it's a promotional tool. And so I believe, and I'm looking at the partners here, that there is indeed room to improve that protection because I don't know if somewhere we're not, why we ended up with this non-binding or progressive implementation provisions, but indeed in practice they are not giving results. And many countries where there is no goodwill, there's no even for ADILO, no tools to force them to develop these facilities. So thank you so much, and thank you for your questions.